cross over to the IEBC headquarters, where they're delivering a ruling on a McDonald Mariga's appeal to the invalidation of his candidature for the Kibra by-election,
in which he only sought, according to the ground B, on the face of the subject application, for leave to be enjoined in proceeding as interested party on the ground that he intended to advance centrality of integrity in the electoral process, and particularly in the Kibra by-election. The application did not seek any other substantive prayers or order. In its ruling on the application, the committee directed the second interested party to limit his representation to the matter under consideration in the complaint, with a rider that any other matter not touching on the complaint should be addressed in a different forum. Consequently, paragraph 12, 13, 14, and 15 of his affidavit in support of the application were expunged from the record. The dispute. The dispute before the committee arises from the respondent's decision of 10 September 2019 rejecting the nomination of Complainant as a candidate for the forthcoming Kibra by-election for the reason that the complainant data was not found in Kenya Integrated Electoral Management System, KIMS. In his complaint, dated 11 September 2019, the supporting affidavit sworn on the same date, complainant averred that the respondent's decision was improper, null and void for want of lawful invalidation, since the complainant is a registered voter. Complainant further asserts that he was registered as a voter on 26th of August 2019 at Karioko Social Hall, polling station in Starehe constituency, and was issued with an acknowledgement slip bearing electorate number 0145-211-90826-1205-9. It is his contention that he met all the requirements of the nomination as was confirmed by the first interested party in its replying affidavit sworn by Andrew Musangi on the 13th September 2019. On the account of foregoing, he praised at paragraph 7 of his complaint that this committee should make a finding that the decision of the respondent is void and of no legal effect, and that it be determined that the complainant was validly nominated by a political party, that is Jubilee Party of Kenya, and his nomination affirmed by the issuance of certificate of nomination by the Commission for the position of member of Kibra constituency. The jurisdiction of this committee. The jurisdiction to hear and determine dispute relating to or arising out of nomination is donated to the Commission by Article 88, Sub-Article 4E of the Constitution, Section 74 of Elections Act, Regulation 99 of the Election General Regulation 2012, as well as the rules of procedure and settlement of dispute. To this end, Article 88(4) E of the Constitution provides that the Commission is responsible for conducting or supervising referenda and election to any elective body or office established by this Constitution, and any other elections as prescribed by the Act of Parliament, and in particular, Section Sub-Article E state that settlement of election dispute, including dispute relating to or arising from nomination, but excluding election petitions and disputes subsequent to the declaration of election result. The above provision is replicated under Section 74 of Elections Act and Section 4 of Independent Electoral and Boundaries Commission Act 2011, which outlines the function of the Commission. Thus, pursuant to Article 88, Sub-Article 4E of the Constitution, the Commission shall be responsible for settlement of election dispute, including dispute relating to or arising from nomination, but exclude election petitions and dispute subsequent to the declaration of election result. Under Rule 2 of the Settlement of Electoral Dispute Rules, the term dispute has been defined as a complaint, challenge, claim, or contest relating to any any stage of the electoral process, includes an objection to the acceptance of nomination papers of a candidate by returning officer. The purview of the complaint under Rule 9 extends to the complaints relating to whether the candidate has all qualifications required under the law, under any law. In the case of Diana Kedi Kilonzo and others versus IEBC and 10 others, the court stated at paragraph 94 of the judgment that a reading of Article 88(4)(e) of the current Constitution and Section 74 of the Act clearly shows that IEBC has powers to settle dispute, including nomination dispute, other than election dispute arising or subsequent to declaration of result. The mandate to settle dispute, therefore, runs up to the election date. The committee hence had jurisdiction to hear complaint of the interested parties. Guided by the above provision of the law, we are satisfied that the committee has jurisdiction to determine the present dispute. We now proceed to consider laws applicable to the resolution of the dispute. The applicable laws. Article 38(1) of the Constitution guarantees the right of every person to exercise their political right, which includes the right to A, to form or participate in forming a political party, B, to participate in activities of or recruit members for a political party, or to campaign for a political party or cause. Additionally, 38(2) provides that every citizen has the right to free, fair, and regular election based on universal suffrage and free expression of the will of electors for any elective public body or office established under this Constitution, or any office of any political party of which the citizen is a member. In order to exercise the right, it is the right of every person to be registered as a voter or to vie for a public or political office. Thus, under Article 38(3) of the Constitution, every citizen has the right without unreasonable restriction: A, to be a registered voter; B, to vote by a secret ballot in any election or referendum; C, to be a candidate for a public office or office within political party of which the citizen is a member and if elected to hold office. The right to participate in electoral process, either as a voter or as a candidate, connotes the basic element of democracy. Justice Mativo, in the case of Ekuro Ekot versus IEBC and 3 others in 2017, that expressed himself as follows. At paragraph 82, he quoted Article 38 of the Constitution and stated it guarantees political rights, which include the right to be a candidate for public office. Undoubtedly, the right created under Article 38 of Kenya to participate in electoral process is integral part, and for the sake of convenience, he called it an element of the basic feature of democracy. In paragraph 83 of his ruling, he stated there are 2 important points to note. First is that the right to participation in electoral process, which will include both voting and standing for election, is part of the basic structure of democratic state, which will mean that restriction upon participation in electoral process can only be justified through a very strong reason and in a way that the core of the basic feature of democracy is not damaged. Secondly, Even more importantly, while the right under Article 38 and Article 27 of the Constitution are not absolute right, they cannot be limited except by law, and then only to the extent that limitation is reasonable, justifiable in an open democratic society. Any limitation must be subject to three-part test. A limitation will only be accepted when prescribed by law. B, when it is necessary and proportionate. C, when the limitation pursues a legitimate aim, namely the interest of the national security, public safety, prevention of disorder or crime, protection of health and morals, and protection of right and freedom of others. The principles for conducting election are set out under 81 of the Constitution. They include freedom of citizens to exercise their political right under Article 38 and universal suffrage based on aspiration of fair representation and equality of vote. The qualifications for one to be registered as a voter are outlined under Article 83(1), which stipulates that 1, a person qualifies for registration as a voter at election or referenda if A, is an adult citizen, is not declared to be of unsound mind, has not been convicted of an election offense during preceding 5 years, and 2, a citizen who qualifies for registration as a voter shall be registered only at one registration center. Article 83(3) further provides that administrative arrangements for registration of voters and conduct of election shall be designed to facilitate and not deny an eligible citizen the right to vote or stand for an election. Commission is obligated under Article 88(4)(a) of the Constitution and Section 4(a) of IEBC Act to conduct continuous registration of citizens as voters to undertake regular provision of voters' roll. Section 2 of Elections Act defines register of voters as a current register of persons entitled to vote at an election prepared in accordance with the Section 3 and includes a register that is compiled electronically. It is duty of the Commission to establish register of voters, which under Section 4 of the Election Act comprises of A, a poll register in respect of every polling station, a ward register in respect of every ward, a constituency register in respect of every constituency, a county register in respect of every county, a register of voters residing outside Kenya. Whereas Article 84(a) of the Constitution as read together with Section 4(a) of IEBC Act requires the Commission to conduct continuous registration of voters, there is limitation imposed by Section 5 of the Elections Act, which provides that 1, registration of voters and revision of register of voters under this Act shall be carried out at all times except A, in the case of a general election or elections under Article 138(5) of the Constitution between the date of commencement of 60-day period immediately before the election and date of such election. B, in case of a by-election between the date of declaration of vacancy of the seat concerned and the date of the by-election. Any citizen of Kenya who has attained the age of registration and the age of 18 years, as evidenced by either national identity card or Kenyan passport, whose name is not in the register of voters, shall be registered as a voter upon application in prescribed manner by the Commission. All applications for registration under this section shall be registered in appropriate register by the registration officer or any other officer authorized by the Commission. The registration officer or other authorized officers referred to in subsection 3 shall at such times as the Commission may direct transmit the information relating to the registration of the voters to the Commission for the inclusion in the register of voters. By dint of Section 8 of Elections Act, the Commission is under obligation to maintain an updated register for this purpose. A further obligation is placed on the Commission to regularly revise the register of voters. The process of registration of voters is provided under Election Registration of Voters Regulation 2012 and Election General Regulation 2012, which were promulgated pursuant to Section 109 of the Elections Act. Regulation 13 of the Voters Registration Regulation provides that in respect of the first-time applicant, a person who desires to be registered as a voter shall make an application in Form A set out in the schedule. An application under Sub-Regulation 1 shall be made to the registration officer for the constituency in which the person wishes to be registered. The application for registration as a voter may be made at any time except on the occasions provided under Regulation 15, namely during the time in which registration of voters and revision of register is not allowed as provided under Section 5 of Elections Act, and during period in which the Commission has suspended applications by way of notice published in Kenya Gazette, as was done by the Commission in respect of Kibra constituency via the Special Notice Gazette, Special Issue Gazette Notice carried in Volume 106, published on 16th of August 2019. Regarding the process of registration, Regulation 13A of the Voter Regulation provides as follows. 1. A person who applies to be registered as a voter shall present his or her identification document to the registration officer stationed at registration center of his or her choice. 2. Registration officer shall, where applicant is qualified to be registered as a voter, issue applicant with Form A as set out in the schedule. The applicant shall return the duly completed Form A to the registration officer, and the registration officer shall confirm the details in the form and enter them in the biometric voter registration system and the voter's record book. The applicant shall be issued with an acknowledgement slip upon registration. Under Regulation 16.1 of Voter Regulations, the registration officer to whom an application is made under Regulation 13 or 14 shall consider application and A. In the case of an application for registration under Regulation 13, register the applicant if registration officer is satisfied that the applicant is qualified to be registered. If the registration officer registers a person or makes changes in the sub-regulation 1, the registration officer shall issue an acknowledgement slip to the applicant. Our understanding of the above cited regulation is that a person is only issued with acknowledgement slip after conclusion of registration process, in which case the registration officer must be satisfied that the person has met the requirement of registration stipulated under Article 83 of the Constitution. Even though there is no express provision on the registration of voters, a reading of Section 9 of Election Act and Article 99(2) of the Constitution presupposes that once a person has been declared to be unsound mind, is adjudged bankrupt, or is convicted of an election offense, then the person is disqualified from being a registered voter. Then the question is, what happens if a registered voter is subsequently declared to be of unsound mind, is adjudged bankrupt, or convicted of an election offense? Within the meaning of Article 88(1) of the Constitution, they are not entitled to be registered as a voter or remain on the register of voters. Even then, disqualification of a voter cannot be whimsical and must be on the premise of grounds and procedures set out in Section 9 of Elections Act, which is reproduced here below. Where a person has been adjudged or declared to be of unsound mind, adjudged bankrupt, or convicted of an election offense, disqualified from being registered as a voter, then if that person is entitled to appeal against decision, that person shall not be disqualified from being so registered until the expiration of the 30 days after the date of decision, or such further period as the Commission may, at request of the person, direct, in order to enable the person appeal against the decision. Insofar as ineligibility of person to vie as a member of Parliament is concerned, Article 99(1) of the Constitution stipulates inter alia that one must be a registered voter, who is defined under Section 2 of Elections Act as a person whose name is included in current register of voters. The same provision has been replicated under Section 24 of Elections Act on the qualification, thus, unless disqualified under Section 2, a person qualifies for nomination as a member of Parliament if the person is a registered voter. Having set down the law which we consider to be relevant, we now turn to the submissions which were made by parties in their support of their rival position. At this point, I will leave it to the chairman to proceed from here. Okay.
Yeah, the submissions of the parties. At the hearing of the complaint, Mr. Ongoya, Mr. Lucy, Mr. Majimbo appeared for the complainant, while Mr. Sigei appeared for the first interested party. The second interested party was represented by Mr. Mbala, while the respondent appeared in person. The complainant relied on his submissions dated 12 September 2019, which were adopted and highlighted orally by his counsels. The gist of the submissions by the complainant is that he was duly registered as a voter on 26 August 2019 at Karioko Social Hall polling station in Starehe constituency of Nairobi County before submitting his nomination papers to the respondent. The complainant contends that he met the requirements set out in Articles 83 and 99 of the Constitution, Section 24 of the Elections Act, and the Regulation 13A of the Voters' Regulations. The complainant further submitted that the definition of a register under Section 2 of the Elections Act is not limited to KIMS, and therefore the respondent's decision to disqualify him was ill-conceived, grossly illegal, and tantamount to taking away his constitutional right due to possible administrative failure and or fault of the respondent and the Commission to upload his biometrics and alphanumeric into KIMS as required under Section 5, Section 5.5 of the Elections Act. In view of this, Mr. Ongoya submitted that the question for determination was whether the complainant is eligible in law to vie as a candidate in Kibra constituency. Making reference to the annexure in the supplementary affidavit, in which there is a remark by the respondent, that's the returning officer, that the nomination of the complainant is invalidated because he has not been found in the register of voters in the KIMS. Council submitted that the committee is called upon to decide whether the respondent was right in law by her decision of invalidating the nomination of the complainant. Council further submitted that under Article 99 of the Constitution, a person is eligible to vie as a member of Parliament if the person is registered as a voter. In the case at hand, Mr. Ongoya submitted that the complainant is the holder of an acknowledgement slip which he had at the time he presented the nomination, papers. The acknowledgement slip bears electors number 0145211908261205-9 and is serialized 0003403985-17. Council also submitted that under Section 2 of the Elections Act, the register of voters includes a register compiled electronically, and that in making her decision, the respondent must have proceeded on the fact that the electronic register is exclusive and not inclusive. Asked by the committee through the chairman on what his understanding of paragraph 90 of the Kilonzo case as regards the issue of the value of the acknowledgement slip, Mr. Ongoya responded that the judgment in the Kilonzo case related to the law as it was in the year 2013 when the decision was made. There had been subsequent amendments to the law as relates to Legal Notice number 17 of 2017, which then, in terms of Regulation 13A of the Elections Registration of Voters Regulations, codified the process of registration, and thus, in his opinion, the Kilonzo case as regards the value of an acknowledgement slip would only apply in this instance. Mr. Ongoya further stated that in the Kilonzo case, the only documentation under consideration was the acknowledgement slip, and that there was no other documentation on evidence of registration as in the case in the dispute before the committee. The first interested party submissions were as follows. On behalf of the first interested party, Mr. Sigei relied on the affidavit sworn by Andrew Musangi, chairperson, Jubilee Elections Board, together with their written submissions dated 13 September 2019. It was Council's submissions that the question before the committee is one on the invalidation of the nomination of the complainant's candidature by the respondent. Council further relied on paragraphs 5, 6, and 7 of Mr. Musangi's replying affidavit, in which he deponed as follows, and we have replicated the contents of those paragraphs. Council also submitted that the party is aware that registration is a continuous process and urged the committee to review the decision of the respondent as it was made in error. The review, in Council's view, would guarantee the party its right to fill a candidate of its choice. The second interested party also submitted as follows. Mr. Mbala relied on the averments in the affidavit in support of the notice of motion application and submitted that Section 24 of the Elections Act, under Section 24 of the Elections Act, one of the qualifications for one to qualify for election as a member of Parliament was registration as a voter. It was his further submission that under Section 5(1)(b) of the Elections Act, registration can be carried out except between the date of declaration of a vacancy and the date of the by-election. The Gazette Notice 7378 declared that there shall be a by-election on 7th of November 2019 in Kibra constituency. The seat was also declared vacant. Paragraph N of the Gazette Notice suspended registration of voters and revision of the register. Council further submitted that the complainant made an application for registration 12 days after the seat had been declared vacant, with the consequence that the purported registration was not legal. He also made reference to the definition of an acknowledgement slip under the voter regulations and made a point that the complainant is not a registered voter since he only applied for registration, hence not in the register of voters. He urged the committee to dismiss the complaint. The respondent filed a response to the complaint dated 13 September 2019 and made oral submissions during the hearing. She is the returning officer of Kibra constituency and stated that she is a seasoned returning officer, having presided over several elections and referenda of 2010. On the 9th and 10th September 2019, she presided over nominations of candidates for Kibra constituency and cleared 23, while 3 of the candidates were disqualified, one of whom was the complainant. She stated that under Section 24(1) of the Elections Act, the KIMS kit bears the gazetted register of voters. She was assisted by her ICT team in the verification of the complainant's name in the register. They were unable to find the complainant's name in the register despite all efforts. She stated that she searched the complainant's details in the register as per details in his national identification card, but could not find the details. Guided by the Election General Regulations 2012, the Elections Act, the checklist, and the nomination guide, she invalidated the nomination of the complainant as, according to her, the complainant was unqualified. She also tried calling the party through a number provided by IEBC for Jubilee Party of Kenya, but they did not pick. When probed by the counsel for the complainant on whether the complainant was called, she stated that she could not have called the complainant because his party had not furnished the commission with the complainant's phone numbers. Additionally, she was asked to confirm that all those who registered before the declaration of the seat vacant were uploaded in the KIMS, and responded that she relied on the register of voters that was provided to her by the commission, and that as an employee of the commission, she works with the register provided by the commission. She further stated that it is electoral practice that once a political party holds nomination, it forwards the names of the candidates to the commission and details are sent to the returning officer. Aspirants then come to the office of the returning officer to register their contacts. Jubilee Party is not a young party, as it has engaged in elections previously, and they know the practice, yet they did not come. She concluded by stating that the 2017 register of voters in Kibra constituency had 118,000 persons. Registration of officers Stare also testified. Mr. Moses Simiyu, the registration officer, informed the committee that he came with the deputy registration officer Ismail Yassin, who was involved in the case. Mr. Simiyu further stated that he was away from office on the material day and requested that the committee to allow Mr. Yassin to give evidence regarding the process. He then invited Mr. Yassin. Mr. Yassin, the deputy registration officer, testified that the complainant appeared before him on 26 August 2019, sometime before midday. The complainant initially did not have his identification card and had to send for it. The actual registration occurred at 12:05 p.m. The electors number 0141210908261205-9 on the acknowledgement slip indicates the date, month, and time of receipt of application for registration. That is to say, 12:05 denotes the time of capturing the voter's data in the kit. 26 denotes the date of registering the voter, while 108 denotes the month, being August, and 19 denotes the year, being by the BVR kit